Welcome to Environmental Law course, dear learner, and today we are going to discuss the Environment Dispute Resolution Mechanism as it has been provided under the National Green Tribunal Act of 2010. India's environmental dispute resolution happens to be a kind of an study which represents the trajectory of the environmental law and justice. And under this trajectory, what we feel that the entire question of dispensing of environmental justice have been a case of utter neglect ever since the oleum gas leakage case, meaning thereby the Shriram Food and Fertilizer versus Shriram Food and Fertilizer oleum gas leakage case and MC Mehta versus Union of India's case. In 1987, the Supreme Court, speaking through Justice P.N. Bhagwati, have tried to look at the entire scenario of the environmental adjudication in India. Because after the Bhopal gas tragedy and the leakage of the methyl isocyanate at Union Carbide India Limited plant in Bhopal have resulted into a deeper crisis to look at in a fresh manner about the working and the efficiency of environmental law. And in that direction, the gas victims and the valiant victims, helpless and hapless victim of the Bhopal gas tragedy happens to languish and had a great deal of trial and tribulation to get compensatory justice and environmental justice. In that reference, the case in point happens to be the MC Mehta versus Union of India, delivered by Justice P.N. Bhagwati in the backdrop of the oleum gas leakage case in Delhi, and which, besides laying down the ratio of absolute liability and coming very heavily on the liability principle of the hazardous processes and industries in this country, have question the very regime of the environmental dispute resolution. Therefore, what we see that the entire background of environmental dispute resolution under National Green Tribunal 2010 is the present law, but its precursor, and as a backgrounder, it is essential to discuss that what was suggested in MC Mehta versus Union of India's case by Justice P.N. Bhagwati. P.N. Bhagwati has laid down a jurisprudence where he talks about that an ecological research group must be created which can help the court of law, because most of the environmental law cases is very specialized in nature, so it requires special evidences, and special evidences, that means that under the general rule of evidence law in this country, that expert evidences are generally not admissible in law, but in an exceptional way that expert evidences can be made admissible. But the question here happens to be that the entire scenario of environmental dispute resolution in this country is largely based on the expert evidences, and expert evidences, as we presume, is also having a multifarious and multidimensional, because one set of expert opines differently, the another set of expert opines differently. Supposing if we say that whether the compressed natural gas as one of the most convenient source of energy to contain the air pollution in Delhi is considered to be the best, but on the other hand, we find there are experts who have deep reservation about application of compressed natural gas driven vehicle in Delhi, because the Delhi witnesses the temperature which goes more than 40 degrees Celsius. So these CNG methods of energy which has been in practice in European country, are the climatic condition in India happens to be different. So for any issue of having some kind of an expert evidences, expert committee, expert opinion, and the court in adjudication of environmental dispute in this country, what it tries to see that it is mercilessly based on the catena of the expert evidences and the multiple sets of the expert evidences, and in that way it is very difficult to dispense environmental justice. Therefore, in this case, as far back as in 1987, MC Mehta versus Union of India, Justice P.N. Bhagwati has desired that there must be an ecological research group which can always work in the aid and rescue of the court in deciding complex, scientifically rich dispute like the oleum gas, like methyl isocyanide gas, like castor oil in Professor M.V. Naidu versus Andhra Pradesh Pollution Control Board. So, what happened in MC Mehta versus Union of India's case 1987, the echo of establishment of environmental court was already there in MC Mehta case in 1987. Therefore, besides laying down the ratio and arbiter about the establishment of the environmental code, be that be said environmental code, be that it will be said the environmental tribunal, be that it can be named as ecological research group, but the idea is that the court of law and the judges trained in the law and administration and dispensation of justice may find very difficult and sometimes appears to be in a very critical and precarious situation of dispensing the environmental dispute. Therefore, there is a need for environmental code. Besides environmental code, Justice P. N. Bhagwati was of the view that besides environmental code, the case in point also talks about that there is a need to relook at the hazardous industry. So, in that context, the case has also talked about a kind of a insurance liability law, and insurance liability law applies to the case supposing the workers are working in the industry and all the industrial law or the labor law guarantees some kind of assurances in case of any industrial accident, but that was confined to the workers only, and that way the entire labor law in this country happens to safeguard to the labor in case of any accident. But if supposing some industrial accident has taken place and besides labor, the people living in the vicinity of the factory have suffered from partial damage, from the total damage, from the partial disablement, from the total disablement. In this case, there appears to be no law. What was the litigation in the Bhopal case right from the South District in New York to to the District Court of Bhopal, to the Madhya Pradesh High Court, to the Supreme Court, and we see this is a case which went to the foreign jurisdiction. This is a case which went to District Court, went to High Court, went to Supreme Court, and the Bhopal gas victim and and the valiant victim of the Bhopal was not able to get compensation because they come out of the pale and purview of the labor law and the workmen compensation law or the employees compensation law. Therefore, Justice P. N. Bhagwati in MC Mehta versus Union of India, beside under noting that there is a dire need for the establishment of the environmental code, also reflected on compulsory insurance scheme. And on both the count, there has been two kind of a development. The one was that the government of India created National Environmental Tribunal Act in 1992. It was drafted and it was prepared. It was drafted in discussed as a bill in 1992, and in 1995 it was made a law. But since this law, National Environmental Tribunal Act, was not appended, gazetted in the Gazetteer of India, that's why we see that this law containing all the salubrious provisions of of the judgment and the ratio of the MC Mehta versus Union of India in relation to creation of the environmental code, this law was not applied right from 1987 to 1995, although it has triggered a debate of constituting some environmental tribunal, and the bill, the draft and the final act was passed, but it was not finally gazetted. Therefore, despite its salubrious provision, India was not having any kind of environmental dispute resolution law till 1995. Thereafter, the landmark case of Professor M.V. Naidu came, and in the landmark case of Professor M.V. Naidu, Justice P. Jagannatha Rao have laid down that if we are not going to establish environmental court in India for adjudication of the environmental dispute, then the people's faith in the judiciary is going to be shattered. And what is important, that the people's faith in the judiciary should remain intact, and the human right to environment which we are talking about, that also it is a negation of the human right to environment in India, simply because of the fact that the country is not having any kind of the mechanism in regard to the environmental dispute resolution and redressal system. And the observation of Professor M.V. Naidu in relation to the castor oil, which was a hazardous substances and process, and the industry was going to be located near Himayat Sagar and Usman Sagar Lake in Secunderabad and Hyderabad. And the question was whether this industry is environmentally benign, this industry is environmentally malign. In both the cases, that there was a set of the opinion by the expert, some group of the experts saying that it is not hazardous, some group are saying it is inherently hazardous, some group of experts was of the view that it is hazardous but certain safeguard is to be taken, and then we can protect the two lakes Usman Sagar and Himayat Sagar. In view of the variety of the expert opinion, Justice P. Jagannatha Rao in Professor M.V. Naidu versus Andhra Pradesh Pollution Control Board have raised certain fundamental question, and that fundamental question appears to be that there is a need for environmental court, and this need for the environmental court was also reiterated. What was reiterated in 1987 by Justice P. N. Bhagwati, it was again reiterated in 1999, it was reiterated in 2001, and the environmental court, and by suggesting that in order to have a very foolproof mechanism and dispense environmental justice in this country, it is very important that as the court is mercilessly dependent upon the expert opinion, and the court's long arm happened to be shortened, and therefore the entire conception of the environmental dispute in India is going to be suffer. And once the environmental justice or dispensation of justice is not done by the court of law, then it is a very serious matter, and it is going to shake the faith of the people toward the judiciary. Therefore, Justice Jagannatha Rao in this case of Professor M.V. Naidu have suggested of New South Wales in Australia, and that model of the court, the Land and Environment Court, was suggested as a mechanism to be Land and Environment Court was suggested as a mechanism to be applied in India, and there is a need for environmental court. Along with what Justice Jagannatha Rao has laid down in this case was the principle of Wednesbury review, and the Wednesbury review as a matter of administrative law require that the very veracity of the administrative action which is done by the Pollution Control Board, State Pollution and Central Pollution Control Board, will come under the basic administrative law jurisdiction of Wednesbury review, and then it tried to question the very process of resolving environmental dispute in this country. With these two cases, my dear learner and viewer, we are going to discuss the very intricacy and complexities of environmental dispute resolution under the National Green Tribunal, and the ball was set rolling, and ultimately what we find that the emergence of the environmental code in this country have undergone to various experimentation. The one experimentation was the National Environmental Tribunal Act 1925. Meanwhile, there was National Environment Appellate Authority Act 1997. All these experiences the Government of India have tried to do in pursuance of environmental justice and resolution of environmental dispute and adjudication. But we see that the creation of the environmental code in India, which was thrown open to perpetual experimentation, and ultimately try to see that those disputes are not amicably resolved. So the Indian judiciary happens to be on the throes of transition when it was hearing a case relating to the environmental matter, and therefore in its right earnest, gradually after the pronouncement of Professor M.V. Naidu versus Andhra Pradesh Pollution Control Board case by Jagannatha Rao, the Jagannatha Rao as the chairman of the National Law Commission of India have taken note of this fact, what he has laid down in Professor M.V. Naidu case. Therefore, a a reference to Law Commission of India's 186 report, which is important, which advocated strongly for the creation of a dedicated environmental court to improve the quality of justice delivery system with technical and scientific input, and it has given rise to ultimately some very meaningful discussion regarding creation of National Green Tribunal, and by way of as a natural sequel to right from 1984 Bhopal gas tragedy, 1985 the oleum gas tragedy, 1987 of P.N. Bhagwati's decision, 1999 of Professor M.V. Naidu's decision, and ultimately 2003 of Law Commission's report. This is the genesis, this is the background of what we can say about the environmental dispute resolution under National Green Tribunal, and finally it has given rise to some meaningful debate, and that debate have culminated into introducing the bill in 2000, and ultimately we had a law what is known as NGT in 2010, and it became operational in 2011, and till date this court has almost 14 years of working as a principal court of or we can say a specialized court in matters of environmental dispute resolution and redressal. This court had its branches at Bhopal, at Chennai, and Pune, and Kolkata, and it has decentralized its entire adjudication process, having its headquarters of the principal bench in New Delhi. To improve the access, the NGT also employs a circuit procedure bringing court closer to the remote areas, and it is what is said that the evidences are brought before the court of law. Sometimes court of law itself goes to see what are the evidences prevailing and what are the environmental damages has happened. So this court is a very unique court in that reference, and Supreme Court, which by Justice Kuldeep Singh, has also remarked in a series of cases on the environmental law that there is a need of creation of not only the National Environmental Authority under Section 3, Subclause 3 of the Environment Protection Act, but there is also the need to create environmental court, because the complexities of the environmental dispute resolution is acquiring some kind of a proportion that the ordinary court of law is not in a position to appreciate and to reach to a conclusion and reach to a judgment which can satisfy all the party and serve the end of justice. And ultimate purpose of the judiciary is not the travesty of the justice but dispensation of the justice. So that goal was taken into care. And after the establishment, Justice Kuldeep Singh has also tried to move this idea in the Supreme Court that there should be constitution of the green benches, and a green bench was constituted in the Supreme Court to hear environmental cases. But after the establishment of National Green Tribunal at New Delhi and its affiliate at Bhopal, Chennai, Pune, and Kolkata, then all the cases of the Supreme Court, right from Gas Pilit Mahila Udyog Sangathan vs. Union of India, it started from Bhopal, and it again, the entire cases of the Supreme Court have been transferred to a National Green Tribunal, and that was also a very metaphorical in this sense that this case has ultimately paved the way that all the cases which are pending before the Supreme Court may kindly be transferred to the National Green Tribunal. By 2015, we see that there are more than 300 cases which were transferred, and Supreme Court is actively reduced its environmental case backlog to reinforce NGT's role, and thus NGT as a very significant and effective dispute redressal mechanism and institution contributing to the environmental governance, law, and justice, taking totality of the view of the scientific expertise and the judicial process. The aim and scope of the National Green Tribunal appears to be that this is a law which is going to affect at least five. The Schedule 1 provides that what is the ambit and scope of this law, and for the ambit and scope of this law, we will directly go to number 1 is the Water Act. Number 2, it is Forest Conservation Act. Number 3, it is Air Act. Number 4, it is Environment Protection Act and 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 Biodiversity Act. Although that the appeal mechanism, as we have noticed under the biodiversity chapter, section 52A of the Conservation of Biological Diversity Act, also try to empower the Green Tribunal to look at the entire cases. Beside the exercise of jurisdiction and the ambit of the scope of National Green Tribunal, there is a principle, and that principle must be understood in right earnest, and that principle is very important principle, and that principle appears to be what is called ex debito justitiae, in the interest of justice. So what is the goalpost, what is the anchor sheet before the NGT in deciding the case is what best is served to the interest of justice ex debito justitiae, and the entire adjudicative process involves judges, number 1, and then it involves scientific expert and joint decision making by equal standing, that cases are to be decided by the court of law, and it draws people from ecology, it draws people from environmental engineering, it draws people from forestry, and it adopts a multidisciplinary approach to see the composition of court. And NGT also incorporate from ex debito justitiae and having a very diversified group, as it has been suggested by the ecological research group, as it has been suggested by the Land and Environment Court of New South Wales in Australia, that model is being replicated with this, the very concept of epistemic community, where authoritative scientific knowledge contribute to environmental governance and decision making, and in tandem with the legal norms and prescriptions. Thus, we see that the NGT had all kind of the capacity, stamina, and power and function to look at the question of environmental protection, question of forest conservation, question of national resource management, and enforcement of environmental legal right. And also it is very important for the relief and compensation, because the relief and compensation question was also raised in MC Mehta versus Union of India in 1987, besides the question of the environmental code. And it is also significant to note down that the Bhopal Gas Police Mahila Udyog Sangathan versus Union of India is a kind of a case which tries to get compensation. So relief and compensation is something the hallmark in the National Green Tribunal in the dispensation and the administration of environmental justice. Thus, we see that it has applied Article 21 jurisprudence, which has been meticulously developed by the Supreme Court since last 3 decades, and adding to a kind of a value addition has been done, and that value addition is, number 1, that this is the first law which talks about sustainable development. This is the first law which have made precautionary principle as explicit in the law, in the enactment, and the polluter pays principle also explicit in the act, and thus it promotes not only the compensatory mechanism or the relief mechanism in the entire question of right-based approach to environmental protection. The aims and scope of the National Green Tribunal and dispute redressal mechanism appears to be, at one hand, participatory, on the other hand, it is quasi-investigative agency, because we do not have a agency known as NEPA, which has been passed under National Environment Policy Act of 1969, was an act of USA, and this created an authority, National Environment Protection Authority was created under this law. So we have Central Pollution Control Board, we have a State Pollution Control Board, but it has a term of reference given under the law, but a kind of an authority which was permeated under the National Environment Protection Agency National Environment Policy Act of 1969 of USA, where Article 200 and 201 says that this law tries to preserve the present and future generations of Americans in matters of environmental right and sustainable development. So, in the absence of any kind of a national authority, it is said that this dispute redressal mechanism of the National Green Tribunal, acting as a quasi-investigative authority in matters of the environmental adjudication, is something of a great relief and succor. On the other hand, what this dispute redressal mechanism, the modes and the methods of the dispute redressal mechanism of the NGT is something a great advancement, because it is not purely an adversarial litigation. It means that the adversarial litigation means that the Anglo-Saxon jurisprudence believe in the adversarial process of justice between the plaintiff and defendant and the wrongdoer and the estate, but it tries to liberally interpret the aggrieved person and allowing wide-standing power of the public interest litigations, non-locals, and increasing access to the environmental justice is one of the broad goals of the dispute settlement mechanism. It has all technical tools like e-petition, like geotagging, like video conferencing to enhance the access and transparency. It also tries to expand the procedural power, including on-spot investigation, stakeholder consultation, appointment of expert monitoring committee to ensure implementation and accountability. And this is exactly what we mean, that this act is not purely based on the basis of adversarial process of justice. Therefore, the tribunal undertakes judicial review, and it also takes the suo motu action and where no express authority, a statutory grant has been given, and it tries to protect the larger framework of the environmental right, ensures compliance, and it tries to see a very pivotal role in balancing substantive right as well as the procedural flexibility to enforce environment protection, emphasizing the constitutional safeguard right to life in environmental matter. Thus, we see the National Green Tribunal as an innovative institutional design which have a major intervention and represent a transformative approach to environmental adjudication of dispute and governance in expert-led, participatory, and accountable adjudication beyond the traditional and the Mundarian criteria of the adversarial process of justice. With this, we try to see as to what underpins into the preambular assertion of the National Green Tribunal Act 2010. Then it says that it is an act to deal with the effective and expeditious disposal of the cases is the one objective which has been heavily seated into the National Green Tribunal Act. With this, that the environment protection and conservation of forests and other natural resources. So that way we see that the entire term of reference of this law in this preambular assertion appears to be very effective, and to have an effective and expeditious disposal of cases, and number two, cases relating to environmental protection, conservation of forests, other natural resources, gives a larger platter to the National Green Tribunal Act 2010. And what this role is going to happen is, number one is the enforcement of the legal right or environmental right, and number two is giving relief and compensation for damages to person and as well as the property. Here again, the section 2A of the Environment Protection Act become important, which defines environment protection, including human being, plant, microorganism, living creatures, property, and the entire environment. So the idea of giving the relief, which was permeated under 1987 decision of the MC Mehta versus Union of India, and which ultimately led to passing of the Public Liability Insurance Act 1991 and 1992, that kind of a relief beyond the purview and pale of the labor law was also granted under the preambular assertion. And again, as the different laws in India happens to see and attributes its origin and genesis, that this law also gave credit to United Nations Conference, to Stockholm Declaration 1972, and call upon to make appropriate step to improvement of the human environment. So we see the role of the National Green Tribunal 2010 in the perspective of, of a greater role to play on all overarching problem of the environment in India and enforcement of the environmental right and right to environment, and at the same time giving relief and compensation for the damages, and thus having set the tone and tenor of the National Green Tribunal Act 2010. It also tried to give credit to the Rio de Janeiro summit of 1992, where India has participated, and it tries to dwell on the aspect of one thing. Again, it is reiterating remedy and national law regarding liability. It is an obvious reference to Article 15 of the Rio Principle, which talks about that there must be some kind of a remedy and there must be some kind of a national law regarding liability and as well as the compensation and, the environmental damages. So this aspect, which has been ipso facto have lifted from Article 15, was heavily seated in its preambular assertion, and it also talk about that how this law is going to enforce the question of environmental right as it has been envisaged in the first paragraph of the preamble. It says that whatever judicial pronouncement in India, meaning thereby right to healthy environment, which has been permeated and which has been the jurisprudence which has been handed down by and construed, interpreted by the Supreme Court and the High Court, then all those judgment is going to be a kind of a guiding force in giving effect under Article 21 of the Indian Constitution to declare right to pollution-free environment, right to ecological balance as a matter of fundamental right. So what has been said as a fundamental right by judicial pronouncement, and what exactly we mean that by Article 141 of the Constitution of India, that the law declared by the Supreme Court shall be binding on all the court within the territory of India under the principles of stare decisis. This court is going to have this kind of jurisprudence to be intact to articulate right to environment. And lastly, it says that it is considered expedient to implement the decision taken in the aforesaid conferences and have a National Green Tribunal with the involvement of multidisciplinary issue relating to environment. That is a kind of a focus which was suggested in MC Mahathir versus Union of India case, in M.V. Naidu versus Andhra Pradesh Pollution Control Board, and in 183 report of the 186 report of the National Law Commission. All those recommendations have been brought to fruition under this preambular assertion by involving a kind of a court which is more multidisciplinary in approach and try to repudiate the process of adversarial process of justice and try to bring environmental justice to the doorstep of the people. With this, I think that the very understanding of environmental dispute resolution and the National Green Tribunal will augur a clear image and picture that how the environmental disputes are going to be resolved and redressed with vis-a-vis the compensation, vis-a-vis the question of liability, vis-a-vis assertion of right to environment under National Green Tribunal Act 2010. With this, I thank and I wish you a happy learning.